Senator Singh.
Thank you, Mr Acting Deputy President, and I rise to oppose this bill and stand with the Labor Party, a party that certainly represents humanity, dignity of self-worth and compassion, and that is why I stand to oppose this bill. But particularly I would like to start by acknowledging that this is an incredibly significant piece of legislation, and if we go into the depth of it, we can see very clearly that it does incredible damage, not just to the issue or the value of humanity, but also to Australia's international reputation as a country that has signed the Refugee Convention some 50 or more years ago now. And that is one of the points that I'd like to touch on in my contribution to this bill. But firstly, I would like to acknowledge it is complex in its nature, this bill, but it also will indeed leave a legacy. It will leave a legacy for this government that certainly will not leave it in any way in a good stead. It will, and that is why Labor does not accept this bill. There is much in this bill which is in effect a legislative response to actions of the judiciary, some which of it is occurring where the courts ought to be allowed to do their work, and some of it demonstrates very clearly this government's dismissive attitude, as I said, to its international obligations. There is a clear and stark difference between the Labor Party and the Coalition, and it can be seen very clearly in the nature of this bill. That is, the Labor Party like people, we want to help people, no matter what their background. We feel we should treat our fellow human beings as we would have them treat us. And we are better than this, Mr Acting Deputy President. But this government, it seems, is not. It seems that this government does not like people, or at least it has forgotten people. As it basks in its own self-described glories about stopping boats and saving lives at sea, the adults and children who fled their homes, fled their countries because they thought they were going to be killed, that they were endangering their children's lives, spend an average of 413 days behind barbed wire. Some people have in fact lost their sanity in all of that time. Some have lost their lives. Most of the children have lost their childhood. There are 2 young Iranian men who we know very clearly have died as a result of their detention in PNG. Hamid Karzai was declared brain dead in September following a severe infection to his cut foot. His life support was then turned off. How did someone in Australia's care die from a cut foot? Reza Barati was beaten to death by a mob comprising camp guards and PNG local residents who had broken into the centre. Again, how did someone in Australia's care get killed by a mob? It seems to save the lives of refugees, this government is prepared to destroy them. But this government is also prepared to ignore international law in order to destroy the hopes of people who ask for its help. So a self-evident truth over the course of Australian political history has been Conservatives' fear of engaging fully in the international community. Australia had to wait, in fact, till Gough Whitlam to introduce us to the world and world to Australia. The election of the Whitlam government was a turning point in Australia's international outlook. But perhaps most importantly for our global standing, Gough Whitlam engaged deeply with the United Nations. The Whitlam government brought a new emphasis to the United Nations processes and engaged with the organisation more deeply than previous governments. It was under the Whitlam government, for instance, that Labor first made contributions to United Nations funds to support education and other development programs in Africa, and signed a range of significant multilateral treaties, conventions and covenants, a number of which have been left unsigned or unratified by the Australian government for many years. There's some 130 of them, Mr. Acting Deputy President. Some of them including the Convention relating to the status of stateless persons, 1954, 1961 Convention on the reduction of statelessness, the 1966 International Convention on the eliminations of all forms of racial discrimination, and of course the 1967 Protocol relating to the status of refugees. But curiously, the Whitlam government was not responsible for the signing of the 1951 Convention on the Status of Refugees, defining who is a refugee, their rights and their legal obligations of states. That was an achievement of the Menzies government in 1954. So, as I've noted above, in 1973 it was, though, Gough Whitlam's government who was responsible for appending Australia's signature to the 1967 Protocol relating to the status of refugees, which of course removed geographical and temporal restrictions to the Convention. But it is primarily the Refugee Convention, approved by Menzies, which this government now seeks to comprehensively reject in this bill. A convention signed by Menzies. This bill contains a brazen attempt to walk away from this government's responsibilities under that convention. And I want to make it clear for the Senate the Convention's description of a refugee, and I quote, "Owing to well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable, or owing to such fear, is unwilling to avail himself of the protection of that country, or who, not having a nationality and being outside the country of his former habitual residence as a result of such events, is unable, or owing to such fear, is unwilling to return to it." So clearly, this has been too much responsibility for this Abbott government, too much pressure to be humane for this Abbott government, and therefore unable to cope with the basic need to be compassionate. The Abbott government is attempting to wipe the Refugee Convention out of Australia's mind. And I would like to add, as Senator Ludlam highlighted, Australia is very much a successful multicultural nation, a multicultural nation built on migrants and its first people. And many of those migrants are refugees, and they have contributed greatly to this nation over decades upon decades, and will continue to do, including the refugees that have come to settle in Australia in recent times. And we should note that, and note the fact that this is a bill that is trying to destroy the future of those refugees in this nation. Refugees that, under the convention signed by Menzies, were able to rebuild their lives. Why? Because this bill deletes references to the Refugee Convention from the Migration Act, the primary domestic act with which Australia engages, or did engage, with the Refugee Convention. This bill replaces those references with a new independent and self-contained statutory framework, setting out Australia's own interpretation of its protection obligations under the Refugee Convention. In any event, by well-established, accepted and respected principles of international law, this government has no right to self-interpret the scope of its international treaty obligations. It simply does not. According to Jane McAdam, Professor of Law and Director of the Andrew and Renata Kaldor Centre for International Refugee Law at UNSW, basic rules of treaty interpretation state that a treaty must be interpreted in good faith and in accordance with the ordinary meaning to be given to its terms in their context and in the light of the treaty's object and purpose. Furthermore, asserting that a treaty obligation is inconsistent with domestic law is no excuse for breaching it. So what follows some comments, by no means all from the UNHCR's submission to this bill, setting out very clearly its concerns. The UNHCR is concerned that the proposed amendments to the Migration Act would narrow the personal scope of the refugee definition and lead to a restrictive application of rights to Convention refugees. The proposed amendments, Ms. Acting Deputy President, specify that a person does not have a well-founded fear of persecution if reasonable steps could be taken to modify his or her behaviour so as to avoid a well-founded fear of persecution, unless a modification would conflict with a characteristic that is fundamental to the person's identity or conscience, or conceal an innate or immutable characteristic of the person. The UNHCR recommended the deletion of those proposed amendments as they are fundamentally at odds with the purpose of the Refugee Convention. Let me repeat that. Fundamentally at odds with the purpose of the Refugee Convention, a convention signed and ratified by Australia for over 50 years, first signed by Sir Robert Menzies himself. Fundamentally at odds, the UNHCR has highlighted. Why? Because a person cannot be denied refugee status based on a requirement that he or she can change or conceal his or her identity, opinions or characteristics in order to avoid persecution. I mean, the fact that this bill is putting forward that a person should change his or her identity, opinions or characteristics in order to avoid persecution is at itself a bizarre piece of legislation to put forward for people wishing to seek asylum in this country. And as the UNHCR and I completely agree, fundamentally at odds with the purpose of the Refugee Convention. The UNHCR is not aware of any other contracting state to the 1951 Refugee Convention which has removed Article 1D from being a basis for determining the refugee status of Palestinian refugees. As such, the UNHCR recommended that Australia gives effect to its international obligations to Palestinian refugees by codifying in full Article 1D of the 1951 Convention in the Migration Act 1958, agreed to and signed by Sir Robert Menzies and the Liberal and National parties. The UNHCR also recommended the deletion of the parts of the proposed amendments on temporary protection visas, which require Convention refugees to re-establish their continuing need for international refugee protection. No distinction should be made on the basis of mode of arrival in respect to rights. All refugees are entitled to the 1951 Convention rights, agreed to and signed by Sir Robert Menzies, someone very familiar with those in the coalition government. The UNHCR also recommended the deletion of the proposed amendments which operate to limit the entitlement of a Convention refugee to the rights and obligations specified in Articles 2 to 34 of the 1951 Convention, agreed to and signed by Sir Robert Menzies. So I've just noted for the Senate just some of the many problems, indeed downright contradictions, of this bill with our Refugee Convention that the UNHCR has identified in this bill. But I would like to focus, for the brief time I have left, on children, because I know that there is a focus on that in this bill. And I have to say, no one does that better than UNICEF, who have outlined very clearly what these proposed changes to migration law mean for children, how it would widen the immigration minister's powers, how it would marginalise our international law, which I've just outlined, and how it would wind back the ability of Australian courts to scrutinise the government's treatment of asylum seekers. In their submission, they did it jointly, by the way, with the Human Rights Law Centre, Save the Children, Plan, Human Rights Council of Australia and Children's Rights International. They outline the grave human rights risks posed in this bill. And they focus very clearly that under the proposed changes, children born in Australia would be classified as unauthorised maritime arrivals in one of their parents, if one of their parents is a UMA, leaving those children subject to mandatory detention and transfer to Nauru. These children will be born right here in Australian hospitals, right here in Australia, yet they be treated as if they arrived on a boat. Not only does that defy logic, it's incredibly cruel and a clear breach, again, of international law. These changes would render children stateless, and deprive them of their access to healthcare, education and fundamental rights. UNICEF's submission clearly outlines further that, as I just highlighted, the bill would remove references to the Refugee Convention from the Migration Act and replace them with the government's own interpretation, a very watered-down interpretation that I've gone through, and how the Refugee Convention is the cornerstone of international refugee protection and has been signed now by some 145 countries in the world. The government should therefore not just unilaterally redefine it to suit its own purposes. That's what it's doing, out on its own, outside of the 145 countries it joins in ratifying, signing the convention, and trying to unilaterally define it for its own political purposes. I thank UNICEF, I thank the Human Rights Law Centre and all of those organisations, Refugee Council, Save the Children, Plan. Many of them have written to me, many of them I've met. They are at the coalface. They know a lot more than us in this place, the real effects of what this bill would mean on those children seeking asylum, on those parents, on those future refugees that seek asylum in this country. This is a wealthy country, Madam Acting Deputy President. We have the capacity to have a humane approach to refugees in this country. That is what we have been known for decades upon decades. And why now? Why now do we have to bear this government coming and making us this most embarrassing and humiliating country, a country to be ashamed of through its approach to how it treats people seeking asylum and their children, whether they come on a boat, whether they come in any way, shape or form. They're coming because they are fleeing persecution and they need our support. And this is no way to treat them through this appalling act, this awful piece of legislation that completely guts them of any hope of being able to settle and rebuild their lives in this very rich country that we all benefit and take for granted every day. And that is why Labor will not support this bill. That is why we see very clearly that it does nothing to support what values that we stand for, values of humanity, values of compassion. I simply cannot understand why a government would do this to so many people that need our support and need our help, and on top of that, do the undoing of breaching our obligations under the Refugee Convention, taking the Refugee Convention out of the Migration Act, that long legacy that started under Sir Robert Menzies in the signing of this Refugee Convention, continued by great leaders such as Gough Whitlam and all the conventions that we signed under his short leadership. And now to have it all undone. 145 countries that have ratified this convention, and here we stand out on our own as this inhumane, rich nation, putting up the walls, saying, you know, we are not a country of compassion, we are not going to care for refugees, we are going to be fierce and tough and hard What kind of message does that send? That is why Labor will not support this bill. It is an appalling piece of legislation.